Yes, I think we are now streaming live, Sudhir.
Good afternoon and welcome to this Saturday afternoon session on investor state dispute settlement reforms. I'm Sudhir Krishnaswamy and the Vice Chancellor of the National Law School, and may I invite all of you to this panel session. It's an outstanding panel put together in a way that I hope many more panels will be put together with alumni initiative, with Pramod and George stepping up to set this up, and then building a team of collaborators, institutional collaborators who made this possible. Today, that's UNCCI India and the International Council for Commercial Arbitration, as well as the Permanent Court of Arbitration. And this team has brought together a panel of lawyers and Honorable Justice D.Y. Chandrachud, a member of our Executive Council, who we have engaged with, but luckily today we engage not on administrative matters, but on issues of important public and intellectual interest. So my role on this panel is not as a subject expert, to welcome you and get us started, and to hand over to Mr. Gourab Banerji, a senior advocate and someone who has far more specialization in this field than I do, Mr. Gourab Banerji, to move things along.
Thank you, Vice Chancellor. My name is Gourab Banerji. I'm here in the capacity of Vice Chairman of the UNCCI, which is the UNCITRAL Coordination Committee for India. And our job is capacity building. And this, as you can understand, is a very, very important and contemporary topic, particularly since UNCITRAL is now, the working group is now looking at ISDS reforms. So may I just give you a very brief background of the importance of this topic, and then of course I will introduce to you our stellar cast of speakers. So far as India is concerned, we are now facing over 30 odd claims by various investors. Our initial tryst with ISDS was, of course, the Dabhol case, the Dabhol Enron case, which got settled. But then, of course, White Industries came along in 2011, and that was a bit of a shock to the system, because certainly in India, we had not understood that we had entered into a very large number of investment treaties. And though the amount involved was very small, I believe the shock was more because we found a foreign arbitral tribunal criticizing our Supreme Court and the delays in our Supreme Court. And that was a bit of a shock to the system. That case started off, it was a catalyst, it was a small case, but it started off this boom. And we have had a lot of cases with, the 2G licenses being cancelled by the Supreme Court. Some of our panelists are involved in representing our country there. The Vodafone case, where Vodafone, Cairn, Vedanta, where of course the Supreme Court reversed the Bombay High Court, and then the Parliament intervened, the capital gains cases. So there is obviously a lot of interest on this topic in India. The government has reacted. A large number of BITs have been cancelled. We've come out with a model BIT of 2016. So that is one aspect which I'm sure the panelists will comment about. But much more than this, what is relevant in this discussion is the UNCITRAL working group undertaking reform. So may I just briefly indicate some of the themes on which the panelists will be addressing you and giving you their thoughts. One, of course, is this entire interplay between ISDS and domestic law. How does that really work? How does the role of the judiciary play itself out? How does the domestic judiciary, how that balance works? What is the importance of ISDS? I think we have forgotten about the importance of the system, because there is a lot of pushback, there's a lot of criticism both in India and abroad. And are those criticisms genuine? What is genuine and what is just, as it were, fake news? And then, of course, we'll move on to the substantive discussion regarding the working group reforms, which many of you have heard of, and we have experts who will tell you more about their thoughts on the structural reforms, the incremental reforms, and I will, of course, leave it to them to tell you more about these aspects. Now, it's my pleasure really to introduce to you the panel. We have managed at UNCCI in this round to achieve geographical diversity. We have somebody from Singapore, initially from Mauritius, then from the UK, from, of course, Justice Chandrachud from here, Brooks from The Hague. But unfortunately, we have not managed gender diversity. We've had a couple of seminars before this where we've had Gabrielle Kaufman-Kola, Maxi Scherer, and next week we will be having ICSID, Meg Kinnear from ICSID. So despite that minor hiccup, let me tell you that I have personally not seen such a high-powered panel. And let me just introduce you to each of them very briefly. First, of course, there is Justice D.Y. Chandrachud, a sitting judge of our Supreme Court. I can confidently say that, at least for our Indian audience, he would require absolutely no introduction at all. So this is really for all of you who are not that familiar with him. He is a superstar. He has ticked all the boxes: St. Stephen's, Law Fac, the Harvard LLM, the Harvard PhD. He became a senior advocate at an incredibly young age. He was Additional Solicitor General of India. He became a judge very young. Huge loss to the bar from what we hear of him in Bombay and in the Supreme Court when he was a lawyer, and it was a massive sacrifice. If you simply look at some of the judgments he's delivered in the 4 years that he's been in the Supreme Court, I particularly am fascinated by the Aadhaar dissent and also the Navtej Singh judgment. But, you know, actually, it's very unfair to judge him by his CV, because what we see of him in court, and the difference there really is between intelligence and wisdom. And let me speak for the younger members of the bar. The kindness with which he treats members of the bar and the depth of knowledge is really what I believe sets him out. So you will hear much more from him. Welcome, Justice Chandrachud. May I now move on to Toby Landau? And here, of course, again, I find it very difficult to say anything about Toby that everybody in the planet has not heard about. So Toby is known to everybody in the international circuit. Again, he has ticked all the boxes, Oxford, Harvard, Eldon Scholar. But I think the real break that Toby got was just when he started out, his association with Lord Savile and the expertise that he brought and his knowledge of the 1996 Act. And from there, it was just, you know, stardom followed. He has sat in hundreds of tribunals. I can think of 3 judgments offhand: Dalla versus Pakistan, Jivraj versus Hashmi, and then the recent Halliburton and Chubb. He is the only QC to have proper rights of audience in Singapore, an astonishing achievement probably after the Astro-Lipo series of litigations where he argued in Singapore and Hong Kong. But let me tell you personally, my first interaction with Toby was, interestingly, in White, Australia. And behind that affable nature is a very sharp, analytical mind. And one thing that I definitely noticed about him then, and I would urge all our younger members who are listening to this now, is all you need to do is to go on YouTube and hear him speak, because it's such a pleasure. It's like a Rolls Royce purring. You know, he can convince you of anything. He's got a silver tongue. And I must also mention personally that I have had the privilege of the legendary hospitality of Toby and Nudra. So welcome, Toby. I move on to Salim. What can I say about Salim? Let me start in a different way about Salim. The first time I came across Salim was when he was presiding over an UNCITRAL working group session in Vienna. So I looked at this man who was tall, cadaverous, with this foppish hair, and I wondered, who is this man? And then when I got to know him, I then realized that behind that sort of barristerial look is somebody who has the widest and most widest education and widest interest that I have come across. He's from Mauritius. He's African, if you can accept that. He spent a lot of time in France. He has an amazing, he has, I believe, a 5-year degree in mathematics with political science, and of course then followed by the double first at Downing. Again, my interaction with him after the UNCITRAL meeting was in matters where we appeared on the same side. He has a very methodical approach to things, and he is again an international figure. He's sat in a large number of arbitrations. He has experience with UNCITRAL. He drove the Transparency Convention. I remember him discussing it in that 2011 working group. We were in Mauritius for ICA 2016, where he was, I would be confident in saying, master of ceremonies. His reach and knowledge of people across the world is frankly unparalleled. Welcome, Salim. Finally, last but not least, may I introduce Brooks Daly. Brooks and I go back a long time, but let me say that the PCA is something that we in India are really familiar with. Brooks is the Secretary General of the Permanent Court of Arbitration. He looks after 122 member states. He also makes arbitral appointments. He was earlier with the ICC, the ICA. He's a member of the California Bar. He was a member of the California Bar, is a member of the California Bar. But so far as India is concerned, Brooks is a friend of India. He has negotiated a host party agreement with India as long ago as 2008 with the then Attorney General and Mr. Nariman, who is the chairman of UNCCI, and he's a great supporter. We look to him when the PCA supports UNCCI conferences in India and when the PCA deals with India. So there you have 4 stellar speakers. I'm now going to tell you a little bit about our two speakers who are going to introduce and moderate the topic. Pramod Nair, again, very familiar to us in India. Pramod is an alumnus of the National Law School, which is why we are all here. He graduated top of the class. He then went to Cambridge. I have worked with Pramod closely in a number of matters. He's been an arbitrator, I mean, whether it is LCIA, ICC, SIAC. He's one of the very few people in India who understands ISDS, and he's also a teacher, and he's a star in the making. I do not be deceived by his youthful looks. You will find out more about him when he grills the speakers. Last but not least, may I turn to George Pothan. George is the go-to man for ISDS in India. He is closely associated with the government. He's been consulted by them as an expert in a number of matters. He's represented the country in various delegations, particularly to UNCITRAL. He is, of course, part of our UNCCI group, and he is the person to whom we all turn if we need any assistance or any help, because he is an absolute encyclopedia of India's engagement with all the various BITs. So there you have it, ladies and gentlemen. That's our panel. I will hand over to them, but before that, may I just take one moment to thank the National Law School, to thank ICA, and to thank the PCA, Live Law India, and Rashid. Over to you, Prabhu.
Thank you, Gourab. Thank you, everyone. I think we will dive right into the discussion because we have a huge number of topics to cover and very little time, relatively speaking, to cover the range of topics that we have. Many of the topics that we have for discussion today are issues that have been covered in a number of conferences across the world. In fact, this is the third conference on ISDS reform that's being organized by the UNCCI. So we will be covering much of the ground that has been covered before. But no doubt, we will have new insights and perspectives, especially with the range of expertise and experience of our panelists today. What we have done is we have divided today's session into 4 main themes. The first theme will look at the interaction between ISDS and domestic law and the relationship between constitutional law principles and ISDS. We will then move on to rethinking the purpose of ISDS and the substantive protections that are contained in BITs. The third theme will be to discuss the reasons for some of the fault lines that have become apparently more evident as we go along. And finally, the core topic that we will be discussing today, which will be the bulk of the discussion, will be the various proposals for ISDS reform. Starting off with the first topic, and this is something I would request Justice Chandrachud to take the lead on. Justice Chandrachud, before we focus our attention on ISDS specifically, I think it's perhaps useful to take a step back and consider how BITs are entered into by states. There's, of course, a lot of criticism about ISDS and BITs and the lack of democracy deficit, etc. But the question that is sometimes glossed over is whether there is a democracy deficit in the manner in which treaties of far-reaching importance are entered into by states. Therefore, if I could ask you in terms of your thoughts in respect of treaty making in the Indian context in particular, can the process of treaty making by India and other states be improved to address concerns of a democracy deficit?
Thanks, Pramod. Let me really highlight just 2 or 3 facets of the Indian position, and then very briefly try and extrapolate what we find from the Indian experience. Now, the power to enter into treaties under the Indian Constitution, Article 73 of the Constitution, is vested in the executive, in the national government, which stipulates that the executive power of the Union shall extend to all matters to which Parliament has the power to make laws. Now, under Article 253, Parliament has the power to make laws for India for implementing any treaty or national agreement. Our Supreme Court clarified in a judgment in 1970 that the executive is competent to represent the state in all matters of international law. Therefore, today, the factual position is that Parliament has not enacted any law to restrict the power of the executive to enter into treaties. The current system permits the executive to enter into treaties without referring them to Parliament. Steps in only where legislation is required to effect the terms of the treaty within India. So the executive, of course, maintains that all concerned ministries are taken into account, their views are taken into account, that treaties of national importance are brought before the Parliament prior to their ratification, such as the Comprehensive Treaty on the Banning for Nuclear Tests. Some concerns have been raised that Parliament is more suited to vet treaty negotiations, as it is an elected body, which is in that sense representative of the citizenry. An often quoted instance of this is the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, which was signed in 1994. Now, what happened in the case of TRIPS was that the draft agreement was brought to the notice of Parliament, following which a standing committee was formed. The committee recommended amending the treaty provisions, which were considered to pose onerous conditions to India's status as a developing country, and could potentially lead to a rise in the prices of medicines and have a direct impact on Indian citizens. Now, despite those recommendations, the TRIPS agreement was signed without any major modifications. At this point, just a brief reference to the National Commission to Review the Workings of the Indian Constitution, the famous Chief Justice Venkatachala-headed body, where the Commission recommended that the constitution of a parliamentary committee to review every treaty, agreement, or convention which is proposed to be signed or proposed to be ratified should be something that should be considered in India. In this manner, treaties could be categorized firstly as bilateral treaties which do not affect the economy or the rights of Indian citizens, to those treaties which the executive can negotiate and sign but shall not ratify unless they are approved by Parliament, and 3, multilateral treaties concerning trade, services, investment, and such other issues where Parliament must be involved even at the stage of negotiation. So that really sums up now for you how the democratic deficit arises in India. The constitution in our law gives overarching powers to the executive in terms of treaty formation without any defining parameters of the process which is to be followed before a treaty is entered into. Parliament steps in only if legislation is necessary to effectuate treaties and confer or recognize rights or impose liabilities. Absent that, parliamentary involvement is in that sense limited. There is a considerable body of opinion that the real lawmaking in Parliament takes place in the very serious work which the standing committees in Parliament do. That's where really the brainstorming takes place. And perhaps that's the area where I believe the democratic deficit can be bridged by giving a greater role to the parliamentary standing committees to deliberate and discuss the process of not just the substance of a treaty, but the negotiation part of a treaty, give some element of involvement in treaty formation.
Thank you, Justice Chandrachud. India, of course, has now created a new model BIT.
Yes.
And new model BIT is based on crowdsourcing ideas and suggestions from a wide section of the public. In fact, there was a draft that was circulated before the final version of the model BIT was adopted. So maybe that's a model that works. I'm not saying anything about the contents of the model BIT, which are controversial and which we'll discuss, I'm sure, as we go along. But in terms of the approach taken, I think it's a very refreshing way of doing things. And hopefully that will be the benchmark for future treaties to be entered into by India. Just moving on to the next topic, I think in many ways we think of constitutional law and a constitutional culture as being the prime architects of the rule of law in the domestic legal order. And my question to you is, can ISDS and can BIT protections play a useful role in further entrenching the rule of law in the domestic legal order?
No, there are two very defining trends which I see which are taking place across the globe today in terms of jurisprudence. And that is firstly the internationalization of constitutional law. And the other trend is the constitutionalization of international law. Now, each of these is really a very important trend which is taking place, and which is that increasingly domestic constitutions are borrowing from comparative jurisprudence across the world. We saw that, for instance, in when we held that section 377 of the Penal Code, which penalizes consensual sex between adults of the same gender, is unconstitutional. And we drew a lot from international experience. But on the flip side, there's also a great deal of the export of domestic constitutional law principles which is taking place, which I believe is giving meaning and content to international law norms, particularly in the context of the BITs. You have very broad concepts which are used in the bilateral investment treaties, such as fair and equitable treatment or full protection of services. Now, how do you define, how do you give meaning to these broad terms? And that's the area which really causes so much of divergence of opinion between societies and the sort of, whiplash in domestic territories. I think the impact today, I think, between the engagement between constitutional courts and multilateral investment treaties, and the way ISDS really is evolving, is precisely in this, that these are central or focal points for the evolution of the rule of law. Lord Fuller, spoke about, rule of law not being just in terms of a defined principle of law, but a law which provides for predictability and consistency. So if you do not have law which is predictable and consistent, then that does not serve the rule of law standards either internationally or in domestic context. So 3 points I'd like to make on this point, on this aspect, that the role of the ISDS system can be gauged at 3 levels. First, I would think in terms of the guiding values, which is, of course, what we're going to discuss later on today, which is the key reform area, is a lack of consistency and predictability in decision-making, which detracts from rule of law norms. The second is assessing concrete domestic action, which is that consistency and predictability in ISDS would help states assess whether a change in their regulatory framework may violate their existing obligations under international investment agreements. And the third area, which I want to really emphasize, is that the systems have an interlinkage, where, for instance, domestic legal orders are interlinked with the foreign at the enforcement stage, which is wholly dependent on the support infrastructure and organization of the domestic legal order. This stage, where the ISDS system and the domestic legal orders are interlinked, so to speak, serve as a useful springboard to further entrench the rule of law within the domestic legal order. So I look at this, not in terms of whether we jettison ISDS or whether we just have an incremental approach, as much as to understand that there is a great deal to be learned in our experiences of our engagement with ISDS in, say, the years since 1990, in the last 30 years, in strengthening both an international rule of law, as well as from learning from our shared experiences to strengthen rule of law in the domestic concept, in the domestic context as well.
Thank you, Justice Chandrachud. I mean, that's a very interesting point that you made about ISDS in many ways being a constitutionalization or an internationalization of constitutional law principles. And there is, in fact, an influential body of work which considers BITs or international investment law to be global administrative law. And some of the guarantees that we find in BITs, the right to equality aspect of the Constitution, is something which is mirrored in the national treatment and the most favored nation treatment provisions of a BIT. The fair and equitable treatment standard is mirrored in the reasonable provisions that pervades most international constitutions. The right against expropriation without compensation is again traceable to the right to property that is contained in many constitutions and statutes across the world. So in many ways, what we see in BITs today should not really be startling, because these are standard domestic protections available under a constitution or a statute. So the substantive content of BITs therefore shouldn't really be controversial. And in some respects, I think in terms of decision-making by international tribunals, I mean, despite all the criticism that ISDS has been subjected to, maybe unfairly in some respects, the views of an international tribunal that is distanced from the domestic context can in many respects also focus attention on problem areas within a state and add a sense of urgency to addressing some of those problems. For example, white industries is controversial in India, but it did shine a light on the delays in enforcing foreign arbitral awards within India and the urgent need to take corrective action to ensure that such situations do not arise again. Would you agree that in that sense, the views and the decisions of ISDS tribunals can actually provide an impetus to domestic reform?
Oh, yes, absolutely. In fact, you gave the example of white itself, white industries, which focused on the impact of judicial delays in terms of our ability to perform our international obligations. And that puts sort of a focus on the need for reform of domestic legal structures as well. Though the impetus for reform should not only originate in our foreign investment contracts. The other area, of course, is the Indian experience with claims arising out of the cancellation of the 2G licenses by the Supreme Court, which focused attention on issues that may arise given the overlapping decisions of the judiciary and the executive on the same matter. I don't want to say anything on merits because KHML versus India is still pending, but I'm just flagging that issue. The third is that disputes regarding cancellation of spectrum licenses in Devas or in Deutsche Telekom versus India, which is still pending, highlighted that foreign investors expect more transparency from the executive. And the fourth is that arbitration proceedings in the Vodafone dispute and the proceedings before the domestic courts was a useful lesson on the need for a legislation to enforce BIT arbitral awards in India. So, all these four examples sort of give us some idea of how this interface between the foreign and the domestic is also reshaping the way in which our legal systems configure themselves. At the same time, it's very important to bear in mind that, with all this flexing of, should I say, jurisprudential muscle by countries like India, you must examine this in a political context. After the decolonization took place in the global south in the 1950s and the 60s, the BITs were regarded as an instrument for protecting foreign investments in the erstwhile colonized states. In the post-Cold War world, as there was an exponential growth in the BITs, as you saw liberalization, the growth of global trade. But what really happened, and I think that is the key, as I called it, the flexing of the jurisprudential muscle by countries which have suffered perhaps from the BIT regime, is that when the BITs, the bilateral investment treaties, adopted the ISDS mechanism, they basically superimposed a private dispute settlement mechanism which was appropriate to commercial dispute resolution on a mechanism for settlement of disputes which had a large public law element. Now, a lot of claims, as we have seen across the world, have covered issues like monetary and fiscal policies, environmental regulation, health, taxation. We are in the context of the COVID pandemic, and you can imagine that a large number of decisions which governments across the world are now constrained to take may possibly impact upon their commitments in terms of the bilateral investment treaties. Now, how would a tribunal view it? Would it regard a government as obliged to look beyond just contractual obligations at wider third-party implications? That kind of a thing, So as we go along, I'd also like to briefly mention two examples. One was, of course, the Guatemalan decision to withdraw from a mine closure. And the decision to withdraw from the mine closure, which was taken in the interest of environmental regulation, was due to the perceived threat of a BIT claim. Or where the other classical example is Philip Morris. Here you have the Australian government trying to control tobacco consumption in terms of its international obligations to the WHO, in terms of its own obligations to its people, in terms of public health. But you're faced then with an indirect expropriation claim. The government in New Zealand probably backtracked, seeing what was happening to the Australian government. So, the net result of all this has been that, in fact, the UNCTAD report of July 2020 now states that almost 61% of the claims have gone in favor of foreign investors. And a body as responsible and as respected as the United Nations Conference on Trade and Development tells you, something in terms of raw statistics, which is really the reason why we are now looking at, reassessing the system. Much as we have said, that has had a very valuable role to play in reshaping or reconfiguring our own domestic systems.
Thank you, Dr. Chandrachud. I mean, I think we have many questions for you, especially in respect of the review of domestic judicial decisions by an international tribunal, but probably we could come on to that when we discuss some of the fault lines of BITs. If I could ask you one last question on theme 1. I think you made a reference to the Indian constitutional provisions. There's also a constitutional provision which requires the state to foster respect for international law and treaty obligations, and very specifically encourage settlement of international disputes by arbitration. Do you think that the new draft model BIT, the backlash against BITs, the termination and denunciation of BITs by India is in some ways a repudiation of these constitutional values? And if so, do you think that there's a rethink in India about the role that BITs should play?
The two articles of the Constitution that you mentioned, one is, of course, Article 51C, which states that the state shall endeavor to foster respect for international law and treaty obligations in the dealings of organized peoples with one another. That's how the Constitution is phrased. In Article 51D, which stipulates that the state shall endeavor to encourage settlement of international disputes by arbitration. But however, to state that the recent concerns surrounding BITs and the ISDS process in India undermines these commitments to international law may be an oversimplification of the call for larger reform to improve the ISDS system. For one thing, a number of countries across the world, and I don't think India is an outlier there, a number of countries across the world, South Africa, Bolivia, Venezuela, among others, have sought to reduce their exposure to ISDS claims by either terminating their BITs or by renegotiating the terms of their BITs in recent years. I think this has been due to their concerns over the current system of ISDS being inconsistent, biased, or expensive. Second, over the years, foreign investors have brought claims against a state for a variety of regulatory measures, which we have just emphasized, which strike at the root of or the heart of domestic governance. And for developing countries, these disputes have led to a severe curtailment of their regulatory powers, and that's the perception, I believe. So the concern around BITs and ISDS in India is not isolated, but a part of a larger global trend to reform these mechanisms and draw an appropriate balance between state interests and investor rights. So the better view as supporting reformation to create a uniform or consistent and coherent system rather than rethinking the value of the system as a whole. So lessons from the current system aid in renegotiating future BITs in a manner to make them more equitable towards the policies of developing nations like India. And perhaps in a broader perspective, this concern across the world, and some of the countries I've already mentioned, are a defining moment in the world which is now becoming increasingly multipolar. So much of the legal, legal quest for change is based on the realpolitik of a multipolar world now, where in that sense, power has become diffuse, and it is now, it has changed from essentially a bipolar world as we grew up in at least, as I shouldn't say we grew up in, I grew up in, to what we live in today.
Thank you, Dr. Chandrachud. I think some of those themes we will revisit as we go along. I think that's probably a good juncture to move to theme 2 of today's event. and probably take a step back and consider as to the real purpose served by BITs, and whether those purposes that were envisaged in 1958 when the first BIT was entered into still remain good today. George, over to you for this theme.
Thank you, Pramod. Now, coming to the second theme, the purpose of BITs. Look back in history. Take a look at World War II. It was after World War II, a lot of German investors had lost their investments in various countries. That's expropriated. These were expropriated by other states. So this is what actually gave rise to need for protection of these investors. And if you look in history back to 1958, like Pramod mentioned, the first investment treaty signed was between Pakistan and Germany. And just like Justice Chandrachud had mentioned earlier, if you look at the growth of BITs post the Cold War era, it shows why the BITs were. It is more about the developed countries investing into the developing countries. So from 1958, if you look at where in 2020, when we stand, there are close to 4,000 investment treaties, not just BITs. I'm looking at investment treaties which includes free trade agreements with chapters on investment, or even multilateral investment treaties. India itself, we were late to step onto the investment treaty regime. We signed our first investment treaty with our former colonial powers, British, with UK in 1994. And between 1994 and 2014, in 2 decades, we had signed about 83 BITs, of which 74 were in force. Come White Industries in 2011, when India decided to relook at the BIT regime, we came up with a new model BIT in 2015. And since 2015, we've been terminating our BITs whenever they've completed the initial period, and gone on to negotiate new treaties with partner countries based on a new model BIT. So what have countries looked at? Countries, initially, it was the capital exporting countries who wanted a BIT to provide a certain set of assurance to their investors investing into the lesser developed countries. Over a time, it's gone on to a more balanced investment treaty. And what we see today, we see countries withdrawn from investment treaty. Again, just like we heard in the previous session from Justice Chandrachud, India is not alone in this. We have South Africa who've terminated all investment treaties. We have a country like Brazil, which is perhaps one of the hubs of foreign investment, who do not have a single investment treaty in force. Then we have countries like Australia, which have, when it comes to ISDS, have had a flip-flop. India itself, in its new model BIT, has been more protectionist. That's perhaps having learned our lessons from the past. So the question really is, Toby, if I could put this to you, has ISDS outlived its purpose? And is there a correlation between a robust regime for protection of foreign investment and increased investment flow and investment treaties?
Thank you very much for an incredibly difficult question. It's difficult because it has a number of different components to it. If you're going to ask what the raison d'etre is of ISDS, you actually have to start with the question, what is the raison d'etre of investment treaties? That's one question. The second different question is, do you need to have a dispute resolution system in that treaty? And what's its significance? And they're different issues. Let me address the first one. And really, this is to echo what Justice Chandrachud has already addressed. What is the purpose of an investment treaty? The answer is there is no single purpose. And the great mistake that many people have made in this field, including many tribunals, is to assume that the object and purpose of a particular investment treaty is uniform throughout the world. And where do they get that from? They tend to get it from fairly anodyne language in the preamble to the treaty, which will talk about aspirations of mutual economic cooperation, possibly attracting investment. Actually, if you look at the work of academics who have studied treaty making, and I have in mind in particular Professor Jose Alvarez, his work, as well as Lauga Poulsen, who has written very recently, even in this year, 2020, has published some brilliant analyses on what the actual purposes are or were at the time. And they've listed out a range of different purposes. it's not just about attracting foreign direct investment. The intentions behind the treaty makers over time have ranged over a number of different objectives, including aspirations as to rule of law, including something which is quite different to attracting foreign direct investment, and that is what's called top-down development. That is a mechanism to raise domestic standards by reference to externally anchored norms. That is, norms that can be applied without short-term politics that might get in the way in a host country. Now, if that is the object and purpose, one's looking at a very different mechanism from simply attracting foreign direct investment. The work of Thomas Walder comes to mind. It's often neglected, which focuses on this development strategy. Equally, there's quite a lot to be shown now, quite a lot of evidence that when treaty makers, both in the FCN original versions of these treaties, friendship, commerce and navigation treaties, and then bilateral investment treaties and FTAs, when they were concluded, a lot of the idea behind it in terms of rule of law was to set out anchors around which customary international law could develop. So if you have treaties which are being made which set out principles, if those principles start to take root in state practice, then you will have the development and enrichment of customary international law. Again, it's a very different function to simply attracting foreign direct investment. Now let me switch to the second part. The second part is, what about investor-state dispute settlement, or the actual arbitration mechanisms in these treaties? Well, they, of course, are intended to give teeth to the treaty. So whatever the original objective was, the idea of an arbitration provision or a dispute settlement provision is to enforce and make real those objects and purposes. So if the original objects are still valid, one can well imagine that an arbitration mechanism is a useful mechanism to make the relationship actually work in practice and to enforce it. The last part of the question, however, that you asked is there a correlation between a robust regime for the protection of foreign investment and increased investment flows? And that's what most people focus on here, because they don't think about all the other purposes that actually exist. So foreign direct investment or economic development, the attraction of capital flows, is seen to be really what's critical. So I question that. But if we just focus on that objective, this is a subject of much analysis. And again, it breaks down into 2 points. The first point is, does a treaty, an investment treaty itself, enhance your chances as a country of attracting capital inflow of foreign direct investment? That's one question. The second question is, does a dispute resolution system itself, an arbitration mechanism in the treaty, also enhance your chances of getting foreign direct investment? The first one I can answer easily by saying there's no clear answer. There have been about 40 published studies now about whether treaties themselves actually enhance the flow of foreign direct investment, and the results are inconsistent. There isn't actually there's no clear proof that capital flows are enhanced by the conclusion of these treaties. But the second question I think is even more interesting. What impact does dispute settlement actually have on this objective of attracting capital? And I think one has to take the view here, really, at least I take the view, that there's no basis to say that the existence of an arbitration mechanism actually will do anything in terms of enhancing capital flow. There is no empirical evidence across those 40 studies that I mentioned that arbitration itself, the existence of an arbitration mechanism, actually has a part to play. And if you look at the genesis of investor-state dispute settlement, it is relatively recent. In fact, if you think about it, it's only been around for relatively few years. The first bilateral investment treaty, as George, as you've mentioned, was the Germany-Pakistan Treaty of 1959, but it didn't contain any arbitration clause. For many years, people were concluding treaties without any ISDS. In fact, The first treaty ever to have an ISDS mechanism was 1969, which was the Chad-Italy Treaty. But then they were rare until about the 1990s. So you've got probably about 30 years of people happily making treaties, happily investing, capital flows, but no ISDS. The first ISDS award that people tend to cite wasn't until 1990, and that was the AAL Sri Lanka case. It took another decade, actually, for ISDS to take off. Throughout that whole period, you have got steady flows of foreign direct investment. So I think it's a difficult claim to say that really this is such an important mechanism for foreign direct investment that itself justifies its continued existence.
Thank you, Salim. And like you rightly put, there's no correlation between having an investment treaty and the investment into a country, which even in India's case, one of the largest investors into India is the United States, with whom we don't have a treaty. We've had treaty with a lot of other countries, but we don't have a treaty with the largest investor into India. And moving on, Salim, would you just like to react on to what Toby just said?
Yes, thanks, George. I can be fairly brief. I mean, I agree with pretty much everything that Toby has just said, and I think go a bit more quickly, focusing on, I think, the two strengths that come out from what Toby has said as the potential raison d'etre of investment treaties, and that's not trying to focus on the subjective will of particular states entering into that particular treaty, because as Toby was saying, there's a general assumption that you can just read the preambles and take a very broad look, which unfortunately some tribunals have done. But I think now we can single down on two broad potential purposes. One is this purported correlation between investment flows and the existence of an investment treaty, and then the existence of an investment treaty with ISDS in it. And secondly, the rule of law element. So if I can just discuss both of those briefly. Correlation with investment law, I think Toby is putting in generously. I think no correlation has been demonstrated. It's not if people who are making that claim must demonstrate that correlation. And there are, of course, you've cited a counterexample now with India and the US. There is the counterexample which is often given, and actually a state that's very vocal in working group 3 at the moment, which is Brazil, which has no investment treaties whatsoever with an ISDS. And those who are making that claim, for example, last week I had a discussion at Paris Arbitration Week on a panel with Jan Paulsen, and the evidence which is put forward is, for example, a graph that shows that state aid has tapered off since the 1980s, whereas investment flows have gone up. But with respect, that proves absolutely nothing. One would think that investment into India has gone up because India has moved from being an autarcic country into a country that was open. That's what changed the investment flows. I wouldn't think that the existence in investment treaties per se would have done that on their own. So much for the correlation. As for the rule of law element, I think that more and more academics and practitioners are seeing that as really the core of, and maybe I'm preempting a bit what we're going to now, but why investment treaty, why ISDS in some form should remain. I think what Toby was referring to as external normative power, which is having some external oversight, is good for governance, is good for the structures within the country, and therefore is going to be a major driver of development. So I think that really is where one ought to focus, particularly, and it is very important when one is looking at the reform effort, as we will see in a moment. For example, it shines the light immediately the moment you focus on that raison d'etre. It shines the light on, well, if it is about normative, external normative power, who is holding that normative power? Who are the decision makers? What legitimacy do they have if that is truly the policing element of ISDS? Also, I think what Mr. Justice Chandrachud was saying earlier, which is the rule of law is also, and certainly mostly about predictability and certainty. Are we getting that from the present system? So these would be the remarks I would make at this stage, George.
George, would you forgive me if I just come in with one very quick comment?
Sure.
I just wanted to make this rule of law point real by a very, very quick anecdote. We can talk theoretically about rule of law, but I just want to share with you a very vivid memory that I have of sitting in a Supreme Court in a country which I'm not going to name. I'm tempted. And watching a case in front of the Supreme Court be handled incredibly badly, with all sorts of obvious political pressures coming to bear. And in the course of that, having the Attorney General of that country lean over to me and whisper in my ear, I just hope that somebody brings an international claim. And that was a very poignant moment. It was a real point that actually the issue was political, it had major significance for the country, and what was in the best interest of the country, forgive me, was to actually step outside to an external system, as long as Salim says, that system has credibility to actually discipline the country. So this is a real point.
So sorry, George, if I may, and also you see as well, if you're defending a state in proceedings of this type, that the decision makers, and I mean by that the civil servants actually, rather than the politicians involved, will often feel, why do I need to be accountable to anyone at all? And I have that very often. And I think the very fact that they are asking the question shows you why they need to be accountable to some external norm, so long again as it has legitimacy.
Yeah, thank you, Salim. So what we've seen over time is states moving from the ISDS, what we've seen in Australia withdrawing from ISDS, South Africa withdrawing completely from the treaty. And Toby, you just mentioned the initial treaties never had an ISDS provision. It's also, I mean, you also spoke about what happens in certain countries, courts of certain countries. But that apart, looking at the large amounts which have been awarded by these tribunals, or all the criticism faced with the current ISDS mechanism, do you think an ISDS-free world would be better than what we currently have?
I think one has to fine-tune that question, forgive me for saying, because one question is, would a world without ISDS be a better world? But another question is, would a world with something different to ISDS be a better world? And that's an important distinction. The question is, do we now just abandon any kind of dispute resolution and simply go back to the world before we had this mechanism? Or are we talking about trying to have a different kind of dispute resolution mechanism, different from ISDS? Now, that's something which we will go on and discuss in the rest of our time. But whether now ISDS in its current form can continue, or whether we'd be better off without it, I answer that thinking that we need some kind of mechanism, not that we should have no mechanism at all. I think we must have a mechanism, and we can discuss why. I personally believe, and this is completely irrelevant, as I'm going to explain, I personally believe that ISDS is a very good system and should continue. But that is totally irrelevant, because what matters actually is the perception. For the system to have legitimacy, which is all important, as we've already said, for it to be robust, it's got to be internationally accepted. And I am afraid, and I say this with some sadness, I'm afraid there has been a singular failure of advocacy on the part of all those involved in ISDS, which is remarkable because we all specialize in advocacy for a living, but we have failed. We have failed to communicate why the system works. We've lost that battle. Many people won't accept that who have interests invested in it. But the truth is, if you step out, there is a very vocal, very widespread opposition now. And that opposition is good enough to say we've got to have something different, because the system now doesn't have the acceptability, and therefore it doesn't have the legitimacy that it must have to operate properly. And so whatever we may say about, well, the perceptions are wrong, the perceptions have taken hold. And I think tested that way, I would say that a world without the current system, and therefore the current backlash, would be a better world. But I do footnote that by saying, but we must have something else.
Thank you, Toby. And just to put it across, the Indian BIT, the new model BIT, from an ISDS where we had earlier treaties had perhaps a fork in the road provision, we moved into a system where it provides for exhaustion of local remedies before you go for arbitration. But this exhaustion of local remedies is also not for an undue period of time. It's a time-bound this thing. Exhaustion of local remedies for, say, 5 years before you can pursue ISDS. I mean, international arbitration. So, Salim, would you like to react to what Toby said?
Thanks, George. Again, broadly to agree. Just to give you a feel for what's going on at UNCITRAL, so within what is the Commission of the UN General Assembly, where all states are represented, you have broadly 3 camps. And it's very important to remember this, because I think practitioners, certainly from inside the field, don't realize that. You have those, well, first of all the member states of the UN system have agreed by consensus that there is a need for reform. There is not one state that is in favor of the status quo at the moment within the work of UNCITRAL. And that's following 2 stages of the work, which were to identify whether there were concerns, and if there were concerns, whether they were in need of reform. So everyone agrees reform. And then there's a camp of those who say, well, let's just tweak the current system, which we've been referring to as the incremental reforms. Those that say, well, it needs structural reform in the form of a court or an appellate mechanism, and of course the 2 are not exclusive. But very importantly, you've got a whole group of countries, South Africa and others, and quite vocal, that say, and the NGOs that have been pushing for transparency, etc., are firmly in that camp, that say, scrap the whole thing. So your question is not a theoretical one, it's one which is very alive at the moment. And I would completely agree with Toby, and mostly for these rule of law elements, that one needs to preserve something, and one needs to find a system that has legitimacy, that has acceptability. Whether, and I, again, with respect, completely agree with the point that whether it's perception or real doesn't really matter anymore. When you are on the front page of the New York Times, Bill Cohn, we're supposed to be a technical subject. We're supposed to be something which is simply oil in the machine. We should be transparent. We're everything but. We're in the mainstream media very regularly and always in a negative sense. And I would agree that that tells you all you need to know about whether we need to reform or not. But whether it's only perception, I don't know. And I think, Toby, we've had this discussion in the past as to whether, if you were to create this afresh, would you create it like this? And as Mr. Justice Chandrachud was saying earlier, effectively what we've done is we've transposed into what is a very different field, a mechanism which was created for commercial arbitration. And I think there's a good argument to say that that hasn't worked terribly well, simply because of the fragmented nature of that system. You have a number of ad hoc tribunals that are ruling on standards that are very similar, and therefore that prevents coherence from happening because of the very structure of the system. But otherwise, I agree with what Toby has said.
Thanks. In many ways, if you look at the numbers seem to suggest that ISDS is in rude health. I think the latest UNCTAD report says that we've crossed an important threshold, that the number of known investment treaty disputes have crossed the 1,000 mark. And there are probably 50, 60, 70 new cases being brought every year. And from that, I mean, I think it serves a purpose, it's popular, it's being used, but at the same time, there is a backlash. So if you were to identify, what would be the legitimate concerns that states have in respect of how ISDS is operated, or for that matter, legitimate concerns of investors as well, and how do you separate, in some sense, the negative publicity, and what reasons or what factors would you put into the fake news category as far as the criticisms of ISDS are concerned?
Yes, I think first responding on the introductory point you were making, I don't think it's because investors are bringing claims against countries using the current system that shows you that the current system is in rude health. You might have something that's working very, very well for a certain category of persons, and it's exactly the backlash which you're discussing, actors from other, that are looking at other interests of a democratic society are saying, well, that is putting or giving a trump. It's put in different ways, and I won't teach you what's been said. It's again all over the press, and we hear it in working groups very regularly from NGOs, but also from states that are taking those point of views, that it's giving a trump card to investors. It's creating a protection of commercial interests, which, for example, human rights interests do not have, etc., etc. So it's not because claims are being brought that it's showing you the system is working. It shows it's operating, but whether it's working efficiently is another question. Now, the three concerns, the group of concerns that have been identified in UNCITRAL and which are therefore the basis for reform are, firstly, coherence, consistency. Secondly, the decision makers. And thirdly, what one could call efficiency, which is effectively time cost, I mean, this sort of consideration. And of course, the three interrelate, but these are the three. As to whether they are fake news or not, I don't think it's a terribly productive debate, exactly for the reason that Toby has given. And because it's the debate which allows, again, a lot of practitioners at the moment who just want to bury their heads in the sand and not see what is actually happening from engaging with the reform effort. And I think all of us need to engage because, fine, states may have a will to reform, but they need the expertise of those that have been working within the field if they are going to reform meaningfully. Say, if you're going to create a new court today, you need practitioners who know what this field entails. You need to try and avoid the pitfalls of other international courts that we know of about neutrality, etc., etc. So whether fake news or not, I'm not sure is a terribly good question. But I think I've sort of already answered your question by saying, certainly for my part, and I think it's been the point of view of quite a few of the states that have been in favor of structural reform at UNCITRAL, what is not fake news is the very nature of the system. That you have, by definition, a fragmented system where you're going to have standards that, of course, are not identical from treaty to treaty, but being interpreted in ways that are going to vary. And to give you an example, I don't think it's normal that every time you're analyzing an FET clause, the state will wheel out international minimum standard, the investor will wheel out TechMed. You know your tribunal is going to end up somewhere in the middle, but you don't know exactly where in the middle. And that's not terribly useful, also for efficiency, but certainly for coherence. And then when some states, very few I must say, have been responding, say, well, you know, because you have different wording, you cannot have, in fact, more coherence than you currently have. And I've never understood that argument. It's as if you were saying, well, you cannot have a domestic law of contract because contracts will have clauses that are worded differently. One can have main principles that would apply, and then obviously take into account the specific wording of the treaty in order to see how they apply.
Well, just to explain the fake news bit, Salim, I think there have been studies which have looked at the percentage of, the outcomes in ISDS cases. And I think there are some interesting conclusions there, because the conclusions are that on a numerical basis, I think there's probably an even balance in cases in which the investors have prevailed, and there's a roughly equal number in which states have prevailed. And even in cases where investors have prevailed, the damages awarded by ISDS tribunals are probably a fraction of what is claimed by investors. So therefore, the criticism that the balance of ISDS has shifted uncontrollably, as it were, in favor of investors may not be entirely backed up by hard facts.
But with respect, I'm not sure these surveys prove anything at all. It's not because cases are going this way and that way and damages are lower than what is being claimed. I don't think that's telling you anything at all about how the system is operating. Because if you're talking to someone who's coming from a completely different outlook, and our cases raise issues which bring the attention of people with a completely different outlook because they're intensely political. We were talking earlier about Philip Morris, you're talking about public health measures, et cetera, et cetera. They would question the very premise that why are you giving this additional protection to a certain group of interests which are purely commercial interests, which is not to neglect them, but human rights interests are also fairly important. And that feeds into, for example, how you might structure a court, because you find that those who want human rights issues to also be capable of adjudication, to say, well, if you're going to make a court, make it a broad jurisdiction. Why limit it to the protection of the interests which are under this specific class of treaty? So, and again, I don't think that's fake news. It's fake news. Put it differently. It's fake news if you're wearing the blinkers of practitioners in ISDS. Because I agree with Toby, we can see it works. We can see that there's fairness involved. We can see that there are legitimate decisions being rendered. But if you're from outside that narrow field, you look at things quite differently. And I think we need to make the effort of seeing that broader picture.
I wonder if I can just, can I come back on that, Pramod? Sorry to interrupt the flow, but I think it may be worth and may be helpful to everyone just to explain a little bit more about why we're saying that the commercial arbitration model doesn't work. Why there are tensions that are being set up in the system because of the superimposition of a procedural model that doesn't really fit. Because not everybody may realize that. And to be frank, many arbitrators in this field don't realize it either, which is one of the core problems. There's a mindset problem because people who tend to be arbitrators in this field have grown up in commercial arbitration. As this field has grown recently, they have reinvented themselves as public international lawyers and now get appointed in investor-state cases, but their mindset has never changed. And that is a root cause of the problem. And it causes a lot of the consequences which Salim has described. So very, very briefly, the way that I see it is as follows. In a normal commercial arbitration, you have a horizontal dispute. That means you have got two parties who are operating on the same level. They may be usually in a contractual relationship. So two contractual counterparties. They have chosen to contract with each other. They have a dispute which is against each other, and the effects of the dispute resolution mechanism will be visited on them and them alone. Nobody else is bound by the result. But an investor-state case is essentially vertical, not horizontal. It is the opportunity for an investor to question every aspect of the exercise of sovereign discretion by a host state, whether it's executive or legislative or judicial. And that's why it looks much more, feels much more like public law, like administrative law. Because what an investor is doing is not questioning a contractual counterparty. It's actually questioning the way in which a state is governing itself. And the outcome of that could be visited upon a whole population. It could change state policy. And that's why this is a process that raises issues of accountability, which you don't see in commercial arbitration. It raises a potential impact on third-party interests that you don't see in commercial arbitration. And because those interests so far in this field have not been properly accommodated, that gives rise to a backlash. There are people who will say, I never chose these arbitrators, and yet my government's policy is now changing, or has to change. Fundamental points, nuclear policy, cigarettes, health policy, you name it. This field is something of a barometer for world events. Whenever there's a government policy and people don't like it, you now get claims. And so that, I think, is critical to bear in mind when we start talking about how should we shape this process, because one's got to change the mindset. Now, a number, surprising, alarming number of arbitrators don't see it. They come to these disputes and they will say, I don't need to bear in mind any other interests, whether it's human rights, whether it's sustainable development, whether it's environment, whether it's just a local community that might be affected. All I need to think about are the immediate disputing parties before me. And I won't look at anything else other than what they show me. And of course, the system is imperfect, and very often tribunals are not shown the full range of relevant issues. So I think that really hits at the core of what we're dealing with and why there is all this tension in the system.
Thank you, Toby. And Brooks, you've been someone who's seen a vast number of cases from a neutral perspective, been an administrator of cases, or also been involved with Working Group 3 in UNCITRAL. So your thoughts on what you've heard from both Salim and Toby?
Oh, well, I fully agree that fake news is still relevant, even if it's fake. We know the analogy to arbitral tribunals could be taken up that arbitrators can be removed for an appearance of bias. We don't have to prove actual bias to remove an arbitrator. And the same goes for a system that's supposed to be dispensing justice, that if it puts out an image of some sort of fundamental flaw or bias, that that could be a justification for reform whether or not we can really prove such a fundamental flaw. So these stories are still relevant and could be a basis for reform. I would say I'm happy that these UNCTAD statistics have been cited on really both sides in the discussion so far. I think they're very interesting. They do tell us something, but I think it's fake news to say that the success rate of states or investors is determinative of whether or not there is a fundamental flaw in the system. I think you have to go look further, as Justice Chandrachud has done, and link the success of particular parties with problems that we see, that things that we don't think are acceptable, even in cases where he cited also the case of Philip Morris, where Philip Morris actually lost, but the threat of those claims there's clear evidence that it has delayed the implementation of plain packaging legislation in several countries. So that has a direct impact on health of the populations of certain countries by the existence of these claims. So I think that we've seen it already in this discussion, the UNCTAD statistics, 32 years of cases crunched, and it's very interesting stuff, but you can sort of draw out what you want from those, and you need to look deeper to draw conclusions. The last thing, as an institution, I would say we often hear arbitration is secret, and that's a problem. And many proceedings are conducted and with some level of secrecy or confidentiality, but that's not inherent in the system. So that is something that there are certain criticisms that could only be addressed by the creation of another system or a replacement with a court, for example. But transparency can be addressed in the current system if the states choose to do so. And the work of UNCITRAL has already provided, with actually Salim chairing that session, the Mauritius Convention, which makes it easy for states to opt into a transparency regime. So I think sometimes the secrecy of the system as being inherent might be fake news.
Thank you, Brooks. So I mean, over time, what we have seen with the system is that it's not, there's no predictability in the system. There's no clarity on the system. Intellect would demand clarity and certainty, but we can also measure progress to be proportional with the capacity to endure uncertainty. And having heard all the criticisms about the system, we also heard a voice that we should not do away with the system, we should reform the system. But before we move on to our next team, perhaps we'll have the last word on this from Justice Chandrachud on the criticisms to the current ISDS system.
George, to my mind, it's not just the aspect of inconsistency which is significant. What is very significant is that there is an element of unjustified inconsistency. So you have, for instance, and that unjustified inconsistency arises from the nature of the process, which is that is decentralized. Now, the core substantive law arises from individual BITs. So that's the first element of decentralization. The second, you have adjudication by ad hoc bodies operating under a variety of institutions. Second level of decentralization. And then you have inconsistencies. It's not a question of fake news. They're facts which stare us in our face. There are inconsistencies between individual tribunals. I'll give you just 3 examples and I'll be done. On the same standard, in the same treaty, in similar situations, you have divergent arbitral outcomes. Critical example there, the Argentine economic crisis, where you had the US-Argentina BIT. You had 4 ICSID tribunals stating that the state necessity defense was not available. You had 1 holding otherwise. Exactly the same treaty, the same standard in similar situations. Point number 2, similar factual situations, the same cause of action in different situations or different treaties, different outcomes. Classical example, the US and the Czech Republic BIT and the Netherlands and the Czech BIT, contrary outcomes. The third, which is multiple actions on similar causes of action, no procedure for consolidation. Classical example in India itself, the retrospective capital gains tax. You have Vedanta, Cairn, Vodafone, the Dutch subsidiary, the UK entity in India. So these are 3 clear examples where the facts stare us in the face. Finally, what I want to really say is this, that commercial arbitration, as Toby just mentioned, the commercial arbitration model ignores two very important facets in their application to public law elements. First, that there are externalities of decision making which are ignored by the commercial arbitration model. Now, those externalities could be in terms of human rights, labor welfare, public health, the environment, which are completely ignored by the commercial arbitration model. Second, and to my mind, which is very fundamental, is that the BIT model dilutes the representative character of governance within the framework of a nation. Intrinsic to a democratic republic, intrinsic to a democratic government, is its ability to alter its policies to suit a changed environment or to learn from the mistakes of the past or past governments. Now, what the BIT model does is to freeze a government to an invariable rule or principle, irrespective of local conditions which have changed. And I think, to my mind, to the extent that it ignores externalities and prevents governments from changing policies to suit the public welfare of the day, I think the model is indefensible.
Thank you, Chandrachud. I think there's been a fair amount of discussion on the criticism of the system, but I think we've only scratched the surface. I think this can go on all day. But moving on to the last theme, because we are actually running a bit short on time, and sorry to cut the discussion short. Moving on to the next theme on proposals for reform. I think there are different models that are being discussed in UNCITRAL Working Group 3. There's one set of reforms which are grouped together and termed as incremental reform. There is another set of reforms which are called structural reforms. In some senses, incremental reforms have been going on for quite some time, and I think probably the effect of that has been to make some changes in a sense and try and demarcate ISDS from commercial arbitration. So if, for example, confidentiality is still the holy grail in commercial arbitration, transparency and openness is probably now almost the norm in ISDS. Awards are published, sometimes submissions are published. There are opportunities now for non-disputing parties to file third-party submissions, etc. So there is this culture of openness, which at least distinguishes ISDS from commercial arbitration. So there have been incremental reforms going on for quite some time. But in terms of what is being discussed in UNCITRAL Working Group 3, Salim, if I could ask you in terms of what really is the today and what kind of incremental reforms are currently being discussed.
Right, Pramod. So we have now reached, as I was saying earlier, stage 3 of our work, which is having identified the concerns, having agreed that there is a need to reform. You have these two tracks. So we've agreed to proceed in twin tracks, one on incremental reform and one on structural reform. And on incremental reform, which is your first topic on this part of the panel, it's still a bit diffuse. I mean, things which are very clear, or for example, which I think you will come to a bit later, the possibility of having an advisory center similar to what's on the WTO agenda, a code of ethics, which interestingly are all things which would also be useful, necessary in a structural reform perspective as well. One aspect which I would like to see more work on, but we haven't really thrashed out even the basics yet, is consolidation, is a way to deal with multiple proceedings. And it may be that actually something could be done which is not onerous at all, and which Toby was hinting at, I think, a little bit earlier, which is simply a declaration by the UN General Assembly highlighting the difference between commercial arbitration and investment arbitration, and encouraging arbitrators and indeed all actors within the system to take it into account and therefore to draw on the tools that already exist when they are dealing with an investment arbitration. So to go back to what Toby was saying earlier, is to tell them your allegiance is not simply to the parties, you have an allegiance to the system. And that simply from an advocacy perspective, if one could have that declaration from the UNGA, one could then use it to say, well, it's not normal that you want to bury your head in the sand, Mr. Arbitrator, when we've got exactly the same proceedings from the same measure proceeding in another guise. We need to try and coordinate. And there are tools to coordinate. They're not perfect at the moment, but there are ways in which you can coordinate. But often you will find that one of the two tribunals will say, yes, why don't we try? And the other will say, no, I don't have to and I won't. So if you just had something like that, it would already be useful. And then the wider problem of consolidation per se, that's much more difficult. But the great thing is that we've got Brooks or Dirk Wilkowski in the room at all times. We've got McKinney there from ICSID. So PCA and ICSID, the two main actors are there. And also the ICSID and the PCA are working very closely with the Secretariat of UNCITRAL. So that there is an opportunity to have within the investment sphere what I think some arbitral institutions are trying to do now, which is to have a power of consolidation which will not work unless it's at least in both the ICSID rules and in the UNCITRAL rules, because otherwise an investor could simply opt out of consolidation by choosing the other option in the treaty, if you see what I mean. So a treaty will normally tell you can go to ICSID, you can go to UNCITRAL, you can go to yet another form of dispute resolution. And unless you have a system of consolidation which applies across that, so either introduced in the treaty by way of a multilateral instrument similar to the Mauritius Convention, or in the ICSID and PCA rules, you're not going to get consistent consolidation. It's a very complicated issue, and there are issues of there are two broad areas to consider if you're trying to create powers of consolidation. One is consent, and the other is the mechanics of it. And it's quite complicated, but I think it will be an opportunity, but we haven't reached that stage yet.
Thanks. Brooks, if I could next on the draft code of conduct for adjudicators, which came out in May this year. Do you think that this is, when it's adopted, if it is adopted, is likely to play a substantive and a significant role in respect of bringing about incremental reform?
Well, I think the idea is good because, as has been mentioned, many of the instruments that do this in the international arbitration world arise out of the commercial arbitration practice, and Investor State has produced some new sorts of concerns about conflicts or appearance of conflict that don't really exist in commercial arbitration. And so having a code of conduct drafted for this area does make sense. It fulfills a specific need. This draft is only a draft now, so I think we can't, it's open for comment, I understand at this point, still in working group 3, so it may be early to draw conclusions about the text, but I see a few, I'll mention 2 things that I think will require further consideration, I think, and that could alter the way it might be utilized if this is to go forward. The first one is a very basic one about whether or not a particular period of time should cleanse an arbitrator of conflict. I see the draft has a provision that is bracketed the number of years at 5, that essentially after 5 years, I would understand by this draft that you do not need to disclose prior professional or business relationships with other parties to the dispute, for example. I think that's a mistake. And I think that it's the same thing that the IBA guidelines on conflicts of interest in international arbitration do. I think that elapsed time is not sufficient alone for determining whether or not an arbitrator has the appropriate level of independence and impartiality. We must look at the magnitude of the relationship. How long was the relationship? And was it a relationship with a party that provided me with 80% of my professional activity for 10 years? These things are relevant whether or not it was 3 years ago or 6 years ago. And so the idea that something is a disclosure item if it was 4.5 years ago, but is not a disclosure item because it's 5 years and 3 days ago, I think that's the wrong approach. And I think they should not have any time limit that cleanses arbitrators in this code. But it's still a draft, so there's a chance to eliminate that. The other one is more subtle, and it's about issue conflict. So this is one of the things that really only arise in investor state. They're not really a problem in commercial arbitration generally. And this is where an arbitrator has taken a strong position on an item, and someone thinks that they can't be open-minded in a subsequent case. And the code doesn't say anything explicit about it, but except in the comments to the code, it says that the disclosure required relating to publications is intended to cover this question of issue conflict. Now, the leading case, I think, recognizing an issue conflict is based on a challenge brought by the government of India in the Davis versus India arbitration. And India argued that an arbitrator had such a clear view, both in arbitral decisions as an arbitrator and as an academic in academic writings, on the interpretation of essential security interests, which was a relevant concept to be interpreted in that arbitration. That arbitrator didn't have the necessary independence and impartiality and should be removed. And the appointing authority in the Mauritius-India bilateral investment treaty is the president of the International Court of Justice. And the sitting president at that time was President Peter Tomka. And President Tomka accepted this challenge and removed that arbitrator. And his finding, which I think is controversial, it's not universally accepted that this is how to define an issue conflict, but what he said was that in arbitration, a party has a reasonable expectation that an arbitrator will have an open mind on an unsettled issue of international law. And this, if I interpret it properly, this actually distinguishes arbitration from national courts or international courts. That is, I don't think the same expectation can exist if we opt for a permanent court. We don't expect a judge or a court, for example, the International Court of Justice or a future investment court, if it has decided on how MFN should be interpreted in relation to jurisdiction, we don't expect them to overturn themselves in the next sitting on this issue. But in international arbitration, this is where I think President Tomka has distinguished arbitration, made it different than a court proceeding, is he has said that if maybe an arbitral tribunal has only one tribunal has decided on a particular issue, and you have a new case on the same issue. Well, if you have the same tribunal, someone from that prior tribunal, that's not in line with your reasonable expectation that you should get someone with an open mind. So this is different. You don't have to accept this, but what he has decided is a different treatment in arbitration than courts. And this is it's a real decision. It's a real precedent. So we have to accept that it exists, and arbitrators should be considering whether they need to conform their conduct to this standard, as it could arise again. It could be a basis for a challenge again. But the code of conduct, while I think downplaying the relevance of that type of conflict, it also says that it should apply to all investor state dispute resolution mechanisms, including a permanent court. And I think that if anyone accepts the position of President Tomka about the difference between arbitration and a court, a permanent court, that this code of conduct needs to be conceived of differently for arbitration and for permanent courts when it comes to issue conflict. So those I think we still have time to see how the debate will go, but that's where I think it needs some more thought, but I think it's a good proposal that investor state does need its own code of conduct.
Thank you, Brooks. I think the draft has attracted a lot of comment, and I'm sure that the new version or the subsequent version of the draft will obviously take into account all the extensive feedback it's likely to receive. Moving on to our next theme. I think one trend that we've seen, well, I think it's probably too limited to call it a trend as such, but we have seen developments where states have come together to issue joint and binding interpretations. And That is sometimes cited as a useful tool to ensure greater consistency in decision making, because if states have a common concern and they've sought to address that common concern by language, if there's any ambiguity in language, it's best that it's clarified by the contracting parties themselves. Do you think that the joint and binding interpretations by states have actually helped in the past to address concerns in relation to inconsistency of decisions? And especially in relation to provisions with fairly open-ended language such as FET, etc., or the more controversial uses of the MFN provision, if states have issued joint and binding declarations as to the real manner in which they intended the MFN provision to be used. Would all these tools help to bring in greater consistency in decision-making in ISDS? Toby, if I could address that question to you.
Yes, thank you. The answer is certainly yes. One's seen a lot of experience, a lot of practice in this area of people managing to get binding or sometimes non-binding interpretations on particular treaty language. The context for this is important. Everybody must appreciate that very often, as the tribunal in this field, you are asked to apply an incredibly broadly, broadly, generally worded provision, such as FET, such as full protection and security, where the wording itself is bland and doesn't give you any guidance at all, and it's susceptible of all sorts of interpretations. And the reason for that is, of course, the nature of treaty making is such that very often the states simply can't agree to the detail. So the only level that they can agree at is one of generality, which is why it's often said that the definition of a treaty is a disagreement set out in writing. But because of that, as a tribunal, you need help. And the best help you can get is if you actually have a common agreement between the contracting states. Where this has worked very well has been those treaties or free trade agreements that have a mechanism in them to allow for binding interpretations. NAFTA is the obvious example. There are some ASEAN treaties that do the same. NAFTA has produced binding interpretations, which have been very, very helpful for tribunals. The difficulty comes for all the other treaties that do not have an established mechanism within them. And then you will get sometimes submissions from one state, and then another party will manage to get a letter from another state. And sometimes that letter will indicate that there is an agreement, but it's difficult to tell how formal that agreement is. As arbitrator, I have been involved in a number of cases where it was just insufficiently clear to say that there was actually a binding agreement between the contracting parties that might qualify, for example, under the Vienna Convention. So I think the way forward here is really for treaties or contracting states to come together and agree a set mechanism whereby binding interpretations can be provided. And that's certainly the thinking behind the new generation of investment treaties, which include much, much more detail than their predecessors.
Thank you, Toby. And we've heard about the issues with ISDS regarding accountability, people wearing multiple hats, playing multiple roles, sitting as arbitrators, sitting as counsel, appearing as expert witnesses. We've heard all these issues with the ISDS system. So this is Chandrachud. If I could put this question to you, what can ISDS learn from state courts? What is it the ISDS mechanism can learn from the courts?
I primary thing which the ISDS mechanism can learn from state courts is that judicial independence and accountability are both crucial to the functioning of any system. Very often judicial independence is considered to be in conflict with judicial accountability. But in a very recent judgment, if I can just refer to that briefly, of the Indian Supreme Court, I was a party to that bench, we considered this question in the case of the Supreme Court of India. Our court was the litigant before us, where a constitution bench concluded that the office of the Chief Justice of India comes under the definition of a public authority under India's Right to Information Act 2005. And we affirmed that independence and accountability are mutually reinforcing concepts which promote three discrete ends: the rule of law, public confidence in the courts and tribunals, and institutional responsibility. So the ISDS, I believe, should similarly aim to build a system based on the principle of these mutually reinforcing concepts of accountability and independence. And accountability in the domestic courts is to the people and to their constitutions. Yes, there's the question of whether accountability of a tribunal is towards the ISDS and to the non-parties to the dispute, or whether it is limited to solving the dispute at hand. This is something which Toby spoke about very extensively. Therefore, conversations surrounding judicial accountability in ISDS also need to address this issue. And I think that is the core of the way forward as we go ahead.
Thank you, Justice Chandrachud. We had Gabrielle Kaufman-Kohler at one of the earlier iterations of our sessions on ISDS reform, and she made a very, very interesting point. The point that she made was people have a tendency to trust institutions. And people have also, on the other side of the coin, people have a tendency to distrust individuals, unelected individuals who have been given vast amount of powers. And in the ISDS context, the unelected people also have the right to second guess exercise of sovereign discretion, a point that Toby had alluded to before. So given Salim, could I ask you, in terms of the current system that we have, what measures exist to ensure greater accountability of arbitrators? Is the good reputation and the need to maintain a good reputation the only form of accountability that exists, or are there other ways and means and checks and balances in the system to extract greater accountability from arbitrators in ISDS cases?
I think Mr. Justice Chandrachud made a preliminary point to this, which one needs to bear in mind, which is accountability to whom? But I'm taking your question as the narrow accountability to the parties, and therefore really focusing on questions of independence and impartiality and open-mindedness to decide a dispute. And there, it's fairly limited, frankly. You've got the only hard way is the challenge mechanism. And I won't go into the detail of that, but they've got their own limitations, particularly within the exit system. And then, yes, as you were describing, you have then the reputation, the way in which the field operates, which in itself becomes a problem, because then you need to know how the field operates in order to judge whether it has the necessary legitimacy or not, which is not brilliant. And we end up having to defend it or criticize it, whereas we are part of it, which is a little bit difficult. Whether reputation is enough, I don't know. You hear a lot of anecdotes, and obviously the elephant in the room is this problem about so-called state arbitrators and investor arbitrators. There is an assumption that this may have been a problem of an older generation, it's going to go away. And my worry is that it's the exact opposite. I think what we're seeing now is a business model. You're retiring from your law firm and you want to make sure you're going to get plenty of appointments as arbitrator in the investment field. There's no better thing to do than to pin your collars to the mast. I'm Mr. So-and-so, and I think you might know who I'm referring to, or Mrs. So-and-so, generation 2. And therefore you can trust me, and that can lead to all sorts of weird and wonderful behavior, including at hearings, etc., etc. So I don't think, to answer the question directly, that we can just rely on reputational risk to create self-regulation.
Thanks. The question of appointment of arbitrators, Brooks, if I could ask you, is there a way within the current system to modify and reform the appointment processes that we have to address various concerns that have been raised and create more accountability? And we will, of course, debate the accountability to whom aspect, which Justice Chandrachud and Salim asked, but in the narrow sense of the term, accountability to the parties before the arbitral tribunal.
Yes, well, Salim mentioned challenges, which is the most obvious way of holding an arbitrator accountable to the standard of independence that she or he must have. But he didn't want to go into it. But I think it's if we look at the statistics under the UNCITRAL rules, it's a rather robust tool. At the PCA, about 40% of challenges have resulted in some change in the composition of the tribunal. So that's it's a pretty high success rate, and so the arbitrators are being held accountable when a good challenge is being brought. Now that the statistics are quite different under the ICSID system, the standard is different in the ICSID convention. I think that Salim made reference to that as well. So one thing is, what is the standard for accountability for independence and impartiality, and is it an appropriate one? And strengthening it could create greater accountability. The UNCITRAL and ICSID standards don't say anything clear else about, say, misconduct or financial mismanagement, whereas some commercial rules do say that. So those are those aren't the typical complaints about.
Brooks, I think you're on mute.
Sorry, can you hear me now?
We can hear you now, thank you.
Yes. So one potential would be expand the grounds for challenge. Another possibility would be that appointing authorities simply take over the appointment process. Now that has obviously costs and benefits, but the Netherlands model BIT of 2019 foresees that the appointing authority will make all appointments. And so what would that address? Well, concerns about, for example, diversity or going back to the usual suspects, that would be remedied to a great extent if party appointments are eliminated. That the Dutch have decided to propose this in their model. They've also set forth the requirement that these appointments show appropriate geographical and gender diversity. So that's something that you don't see in a lot of instruments that could be done. The costs and duration is a common criticism of this kind of arbitration, and some of it is blamed on the arbitrators that they're not moving quickly enough. And I would have to say that the International Chamber of Commerce's measures in recent times to create penalties for slow conduct of proceedings has, I've seen that it has had statistical success. And so if you hit the arbitrators where it counts in the wallet, you might get faster attention. Now, there's a downside to that too, and in cases with exclusively states as respondents, what we see in investor state is it's often the state that requires extensions and more time than investors. States are notified of the claim when the claimant's already had often significant time to prepare. And states have different decision-making processes, which require more time. And so a mechanical, automatic, high-speed arbitration where arbitrators are racing to protect their fees, that's also not going to be attractive, I think, in investor state. But I don't think that's how it works at the ICC and how it could work in other regimes, that they preserve discretion, and if there are good reasons for a case deadline to be extended, that's allowed. And so one option, if you're really worried about duration and speed, is you can arbitrate an investor state case under the ICC rules. Alternatively, we could adopt more of these practices in other systems or on an ad hoc basis. Probably, at least in investor state, we could focus on speeding up the time from the end of the proceeding to the issuance of the award. There's often the proceedings are determined, that the length of them is a factor for the parties and is based on the parties' preferences regarding time. But the time from the end of the hearings and the last submission to the award, in some extreme cases, has sometimes taken over a year, and with no financial consequence for the arbitrators. So that's perhaps some approach taking inspiration from the ICC could also create greater accountability in this system.
Thank you, Brooks. That was very interesting. If we could move on now to the multilateral investment code. I think the core idea is clear that the multilateral investment code, if that's what states ultimately agree upon, will be a standing body of permanently appointed decision makers. But beyond that, I mean, I think the design specifics are less clear. So Toby, if I could ask you, if you were in a sense holding the pen and writing the draft of the establishment of a multilateral investment code, what would be the main design themes that you would flesh out, as it were?
My principal desire would be not to hold the pen, to be honest, because this is one of the most difficult of all the reform proposals. So the three prongs are incremental change, which we've spoken about. Secondly, a multilateral investment court. And thirdly, some appellate structure, which could be an add-on to existing mechanisms. Of the three, the idea of a new court is attractive because it is in some ways the cleanest solution to start again, to start afresh, and build something that actually meets all of the criticisms that we've spoken about. But it is also horrifically complicated as to how one builds something internationally, which is better than, doesn't fall into the same difficulties and traps of existing multilateral courts. And I do not have a ready answer to that, I'm afraid. But whatever it is, it has got to be something which is legitimate and accepted by everybody. It's got to be something which is felt to be representative and doesn't suffer from the institutional and political problems of other existing standing courts. And that is a wish list, which a lot of people will now say is impossible. But I think if there's a will to actually start with a clean sheet of paper, it should be possible in theory. And that would be to break it down to a number of elements. Firstly, does it have to be a physical court? Does it have to actually have an existence like the ICJ with all of that infrastructure? I suspect in these post-COVID days, that seems more of a remote necessity. It could be something which is actually much more versatile and flexible. The critical question is who are going to be the judges? And that has got to be a process of some kind of vetting and some kind of appointment, which is acceptable to everybody. And also it's got to be a process which mixes the idea of tenure, because one of the chief criticisms of arbitration at the moment is that these arbitrators are people who, especially professional arbitrators, are looking over their shoulders at their next appointment. So one has to remove that. Equally, the danger of tenure is that you have to have a system which will allow fresh blood and that will allow itself to be refreshed and not become entrenched and not become politically polarized. And it's got to be a system which is accessible generally to everybody. There are court structures which have already been set up in some treaties. The EU has a model. One can see it in CETA and various other arrangements, but nobody has yet found the solution for it to be multinational. And that is a long answer with no real answer, I'm afraid.
Can I ask you a follow-on question, Toby? You mentioned a wish list and you mentioned a framework. Can I ask whether your wish list will also envisage a role for investors to influence the composition of the body which eventually hears these disputes, assuming an MIC comes into place?
I think that's right. I mean, a lot of people see this field as a vehicle just for states because it's a creation of states. It's not a creation of investors. And people often talk about the field in that way. They say, well, investment treaties are giving an indulgence to investors, but the extent of that indulgence is really in the hands of the states. I think the problem with that is that the system is no good unless it inspires confidence. And that goes back to our initial points about legitimacy. It's robust as long as people will buy into it and accept it. At the moment, we have disgruntled states I'm not sure that we are better off if we have disgruntled investors. And so I think we should be striving for some kind of mutuality, whether it's equal love or equal hatred. It would be wrong to I think, allow states simply to do all the driving.
Thank you, Toby. Salim, is your wish list largely the same as Toby's, or do you have a completely different plan in mind?
Mine might be a little bit more defined because I've been part of the work, and I'm hoping Toby will join us very soon. So you're asking about the core features of a MIC and of a multilateral investment court, and they're obviously the converse of the concerns we have just been talking about. So the three concerns, if you remember. So the first core feature would be that it is by definition centralized or structural. We've been using those words, as opposed to fragmented. That already is a key benefit, a key difference. The second, which is really the problematic one, is neutrality, as Toby has just been discussing, and I can come back to that in a moment. And the third is efficiency, including with respect to enforcement. Now, focusing on the question of neutrality and on the appointment of judges, I think whether the court project is going to be successful or not will be judged by whether one is able today to think outside the box in this specific field and to create a truly neutral court. And there is an assumption by many that, of course, one is going to be throwing the baby with the bathwater, as Toby was saying. You know, it's all disgruntled states, and therefore you can trust them to do anything but what's right. And that's actually not what is happening within the working group. One will see, obviously, once you get into the detail of negotiations, whether this is just sweet talking, but that is not the wish that has been expressed by states who are trying to build a court. They are trying to build a balanced system and a neutral one, which does give a voice to investors, which can come in a number of ways, which can come at the vetting stage, which could come at the appointment stage, which also, of course, comes from the fact that what's very interesting about this project, that is bringing together a group of developed states that therefore will have investors, and developing states. Some of them will also have investors, but many will be just capital importing, so that investors will also feed into what the developed states are going to be bringing to the table. So the assumption that a state will necessarily only be looking at its position as a respondent, I don't think is a correct one. Now, how can you achieve neutrality? And I think the answer is probably in trying to disconnect as much as possible the appointment process from the states. And one needs to make the state swallow that now when you're drafting the convention that is going to create this new court. So for example, no right to a judge. It's not because you're a convention state that you have a right to a judge. And also then, but that I don't have an answer to yet, but try to disconnect the vetting and appointment process as much as possible from the states. And one could, for example, lean on to the existing institutions, which of course have states as their core constituents, but you can see how, if those that are responsible to vet and then appoint would be ICSID and the PCA in some way, which is drafted and put in that convention, and therefore it becomes much more difficult for states to have a direct influence. And then Toby identified the question of tenure. There's the question of accessibility, which you mentioned, and that has two aspects. One is one of pure accessibility, but there's also a question of neutrality, because it's linked to funding. How is this court going to be funded? And there are effectively two models which you can then mix. One is user pays, which is what we've got in the current system. The other is states pay. And there's the idea that if states pay, then the judges will feel that they're beholden to the states. If they have long tenure, that might not be an issue. But my own view at the moment is that we should have a mixture of the two, because that then allows, if you have money that is still coming in from the larger investors who are paying for access to the system, that allows you to fund, for example, your advisory center. It allows you to have funding also for smaller investors that are coming to the court, and you could have a filter of some sort. But also it would avoid that, you know, a country like mine, which might not be of the same size as Germany, doesn't find itself appearing before a court which is largely funded by Germany. So all these questions are on the table, and it's important to understand from what I am seeing, and again, the more we go into the details of the negotiations, and the more one will see whether this is in good faith or whether it's just states talking the talk for the moment. But there does seem to be a willingness from a largish group of states, I would say at least 60 who are totally engaged in it at the moment, to have an open discussion of all these questions with the help of experts, and to try and find, again, the core ideas of a centralized, neutral, and efficient system.
Thank you, Salim. I think that the discussion has been so fascinating that we've really exceeded the time that we thought we would take for this. But we still probably haven't covered half of the topics we wanted to, so we probably need to have round two. If it's okay with all the panelists, could I request that we continue the discussion for another 10 minutes and then open the floor to questions. We've got another alternative to the multilateral investment court, or this could also be part of the multilateral investment court, which is an appellate mechanism. In terms of how the MIC or the appellate mechanism is designed is one question. How it would interact with the existing systems that we have in place is another question altogether. So in respect of the enforceability of the awards, especially whether states or investors would have access to the provisions of the New York Convention, is a point that has been discussed at some length. Could I invite the panelists to provide their views on that? Salim, if I could request you to go first.
Yes, sorry, I missed the second part of your question, Pramod. You were talking about the appellate mechanism and then?
And the multilateral investment court. Would their decisions be enforceable under the New York?
Oh, yes, enforcement. Yes.
And how would this work, for example, in a self-contained system, in the context of a self-contained system like ICSID? So what kind of concerns and what kind of considerations are at play in respect of designing an appellate mechanism and the MIC to cater to these kinds of issues?
Yeah, all right. So that's now three questions, and I'll try to be brief. So appellate mechanism is an essential part of the multilateral investment court idea, because the whole idea is that within 10, 15 years, you will have had appeals on points of law on the more difficult areas, which will have crystallized the law sufficiently, still giving flexibility, of course, because treaties languages will differ. And to understand how it would work, we would be using what is the Mauritius Convention model. That is a multilateral convention, which would do just one thing. It would keep the BIT, the particular BIT, exactly as it is. So say the UK Mauritius BIT, and both the UK and Mauritius have opted into this new multilateral instrument. That then has the effect of replacing the arbitration clause in the treaty and changing it into a reference to the new court, right? So that's how the system would work procedurally. And so the appellate mechanism is absolutely essential, because then you ultimately get into a system where the issues of law are more or less clear. There will still be things that go up to the appeal level, but otherwise one would hope that you're really having a first instance bench of three, say, that is deciding cases on the facts, without having to go through the process we were just discussing earlier of the state arguing for the international minimum standard, etc., etc. So that's on the appellate mechanism. How that then links into the current system is not easy. And some states, China at the moment, China's position is it wants the appellate mechanism, but not the court. And I think that raises some really difficult issues of efficiency, of, as you're saying, how will it work with the ICSID system? That will create difficult issues, I think, under the Vienna Convention. Now, the other difficult issue under another convention you've referred to is the enforcement of awards, of judgments. The easiest answer to that is that it could just be exactly the same system as ICSID. So it would be enforceable in convention countries. I personally think at the moment that it's very optimistic to think that one can define what the output of that court as an award within the New York Convention. But that's up for discussion.
Can I just add one complexity to this? I think what makes all of this even harder is the fact that in the investor-state context, the range of issues of law are actually quite limited. Actually, there are a number of different points on jurisdiction that crop up again and again, notwithstanding differences in treaty language. And then there are a limited number of questions that crop up again and again on admissibility and on merits. So on each of the standards, such as what is the meaning of FET, how do you define indirect expropriation, etc. Because those questions crop up all the time, and because there are a limited number of them, it makes this whole exercise incredibly sensitive, because who will decide those issues first? Who is it going to be who tells us what FET means in this standing appellate system or a standing court? And if they decide it, does that decide it for all time? Of course, there'll be variations according to treaty language varying, but this could be a momentous first few years when all the uncertainties are decided, and then thereafter it may be less momentous because everything's been decided, because the issues are limited. So I think this makes it even more difficult, and I'm afraid, providing an answer at the moment, but it makes it even more difficult, even more sensitive in the way that this is actually structured at the outset.
Justice Chandrachud, would you have a wish list for the design of a new system of ISDS?
I think you're on mute, Mr.
Okay, can you hear me now?
No, we can.
Yes.
Okay, thank you. My take from this discussion is really this, that much as we want a wish list, let's start with the low-hanging fruit and try and achieve something which is realizable. And in that sense, I think if we want to really do something which is realizable, we can think of the two things which I want to emphasize. First, our learning from the pandemic, which is really the immediate situation that we are in today, is that you do not need to have a physical structure for centralization. You can have centralization without physical structures. And I believe that if we do think of physical structures, we are going to get into insuperable problems presently. Second, I think when we address issues of neutrality, it's important that we learn from the experiences which we have gained from other tribunals today, including tribunals such as the ICJ itself, and the intense politicization which has gone into the selection of personnel. And part of the answers in moving towards neutrality would lie in terms of our shared learning experiences from the existing tribunals. The third, which is really a matter of concern for me, is that even if we have an appellate mechanism, what is the standard of review that the appellate mechanism must apply in relation to decisions which are taken by the domestic courts? And I think there, perhaps the European Court of Human Rights would give us some indicator. And there are two standards which I would like to borrow from the European Court. The first is the doctrine of fourth instance, which states that the European Court of Human Rights is not a court of appeal or a court which can quash rulings which are given by the domestic courts or retry cases which are heard by them. In other words, it's not the function of the European Court of Human Rights to reconsider questions of fact on national law. And the second, which is the doctrine of margin of appreciation, which has really been applied across the board in issues of public law by the European Court, which allows greater room to the domestic courts to maneuver in fulfilling their conventional obligations. This is because we must understand that issues under the convention are deeply political questions. Domestic courts are in a better and more democratically legitimized position to give answers to such political questions. So I think just as we design something which is procedurally acceptable, which gains legitimacy, we must equally pay heed to substantive standards which allow for a greater margin of appreciation by domestic courts, which do have that sense of legitimacy and which can build a coherent set of national jurisprudence in addressing problems which deeply affect their own issues of public welfare within their jurisdictions.
Thank you, Justice Chandrachud. What would be the most important considerations in your mind in the design of a structural mechanism to reform ISDS, and how would you envisage it working?
You know, the critical part today for me is that instead of trying to achieve something which is in the nature of another multilateral tribunal, which is likely to take time and the sort of international consensus necessary to build it up, I think from the incremental achievements which we have already made in the last few years and which we expect to make in the next few years, those incremental changes that we achieve will perhaps supply to us the bridge to a more structural reform. Because Pramod, the argument against doing something which is incremental is that will it affect a broader structural reform which is far more significant? And my answer is really very different, which is that when you build incrementally, as we are now seeking to build on incremental stages, this will lay the bridge or the foundation for an international consensus on the need for structural reform. So I think it is the cumulative building up of the incremental stages of reform which will ultimately pave the way for structural changes in the ISDS process. If we forget that, I believe that the real danger will be that we'll not be looking at the increment, and then perhaps we'll not be able to do anything structurally in the future as well.
Thank you. Thank you.
If I may, just very quickly on that point, it's just a question of it's more realpolitik actually, on 2 points which Mr. Justice Chandrachud has made. One on the possibility of working on substance. I think it would be very, very difficult. I think, you know, we say in French, la politique est l'art du possible. Politics is the art of the possible. And that would really be a stretch too far. It's already been very, very difficult to get all states in a room agreeing to work on this procedural reform. I quite agree. I mean, obviously the substantive standards are also very important. To what extent, actually, I think Toby highlighted it, the procedural reform itself may affect the substantive standards quite a lot. But in terms of process, it would be very difficult to work on the substantive standards. And then as to whether one first gets the low-hanging fruits of incremental reform, and that will lay the ground for structural reform. It's actually worked the other way around. It's the stick of structural reform which has pushed all states to say, fine, we now see the problem, so at least we will work for incremental reform. So if there hadn't been that push for structural reform, there wouldn't even be work on the low-hanging fruits from a lot of countries that were very happy with the system as it stands, for good policy reasons.
Thank you. Brooks, any final comments from you on these issues?
Well, this is now on an area that's hard for the PCA to comment on because as an intergovernmental organization, we have various views among our member states. Some of them have no investment treaties, and some of them, and they have very differing views on what the appropriate structure should be of any new mechanism. So the institution is trying to share its experience with its cases that have been brought here, but we're not taking a policy position as the policies of our member states are so varied.
Thank you, Brooks. I think we have a lot more questions to ask, but unfortunately we've run out of time to ask them. So I think if that's okay with the panelists, we'll bring the substantive discussion to an end on that note. And we have, however, been receiving a number of questions from the participants. And could I request the panelists to weigh in with their views on those? I think one very interesting question is on the role of mediation. So in crafting a new model of ISDS, is there a sense that mediation has been underused or underanalyzed in ISDS? Is there scope for, in a sense, insisting on a pre-action protocol, which requires mediation to be exhausted before a dispute can be submitted to an arbitration body or to the multilateral investment court, if that is actually created? And will that, in a sense, pave the way for faster, more amicable and cost-effective resolution of investment disputes?
I can, because nobody else is saying anything, I can step in. I think so far the record of mediation has not been a great one actually in this field. It's been very, very significant in other fields, but what we have seen is that many treaties have cooling off periods, which are designed to allow for some sort of amicable resolution. And it's very, very infrequent that that is a productive exercise, unlike in commercial disputes, where mediation has been incredibly successful. And there are many reasons to one may speculate as to why that is. What's often said is that states find it difficult to mediate these kinds of disputes, especially when they are politicized disputes. It will be difficult often for anybody in a state to take ownership of it sufficiently to actually come to an agreement. Sometimes governments themselves are dysfunctional or they are changing, and therefore there's no will or particular focus to allow a mediation to be successful. That's all so far. I would like to think that in the future people will look to mediation a little bit more. And I think that there are various initiatives that now promote it in a way that we've not looked at it previously. And in particular, I have in mind the Singapore Convention on Mediation, which is now a new arrangement which allows for mediation to arrive at a binding result rather than simply an agreement which can then be set out in a contract. And that's by prior agreement. I think what that does is it actually converts mediation into potentially a fast-track, much more streamlined form of arbitration in a funny way. It will attract disputes that would never have been mediated before because people want a final resolution. But this is now a way of getting a final resolution, but without all the trappings and cost and delay and burden of a full arbitration. There are more and more conferences on mediation in investor-state disputes. There's more and more focus on it. So I would hope that this may be an area that states will reconsider.
Thank you, Toby. Another question relates to the asymmetry in ISDS, where the state is the perpetual respondent. And therefore, ISDS has sometimes been described as a means of enforcing the rights of investors and the obligations of states. Is there scope for reforming the system to ensure that ISDS can also be used to enforce obligations of foreign investors, obligations to the environment, obligations to human rights, and some of the other considerations which Salim, I think you had alluded to as being wider considerations that need protection? If I could request Salim to weigh in on that, with Justice Chandrachud also providing his inputs from an Indian perspective.
And I was alluding earlier to certain states and a lot of NGOs within Working Group 3 saying that one ought to take care that any new court created would have wide jurisdiction. And as I understand it, the idea would be that you're seeing more and more now, if you, for example, you look at the EU-Singapore FTA, not yet enforced, but quite progressive. You now have quite a lot of reference to sustainable development, to exactly these aspects also being taken into account, but in a non-binding way for now. But I think the feeling is that these will crystallize into binding obligations as those treaties progress in time. And therefore the idea, and I don't want to get into the question of counterclaims, et cetera, because how are you going to have a meaningful counterclaim unless there's a substantive standard which clearly creates these obligations? But the idea is that these FTAs, as they evolve, will create those obligations, or at least that's what I'm being told by those who are closer to those issues.
Thank you.
Pramod, I think the way I look at it is that, yes, there should be no reason, at least as a matter of principle, to allow a state as well to lay a claim. But then when we talk of a state laying a claim for, say, a breach, that has to be defined with reference to a substantive standard, as Salim said. So unless we have defined substantive standards which cast obligations on a contracting party, a private contracting party or the counterparty, and which can be complained of in terms of a breach, it would be difficult otherwise to sustain a claim by the state. So when we think of course, you have the procedural counterclaim. That's the least bit of the bothersome issue to my mind. The more difficult question is, how does the state, when the state lays a claim, say for a breach of the environment or a breach of consumer protection by a contracting party in performing its obligations within the territory of the state, then there have to be clearly defined standards within the treaty itself, which define what those obligations are, and with reference to which then a claim can lay in damages or for performance.
Thank you. Thank you.
Could I very, very briefly just add to that? It may not be in the treaty itself. If you look at the arguments that have been made so far in investor-state cases where counterclaims have been brought or there's been an attempt to bring them, for example, Urbesa and Argentina, which is the famous example, where in fact the tribunal held that they could, in theory, rule upon a counterclaim. The obligation itself may not be in the treaty. It may be an obligation that is an international norm that is applicable because of the rules which the tribunal under that particular treaty are entitled to apply. And one sees now, contrary to this, the argument of fragmentation in international law, one sees international tribunals reaching further afield now, looking at norms which may well be applicable within the context of a treaty which gives them their mandate. So it is actually, I think it's an area which is of great interest at the moment, and I would say that should certainly be on the agenda to make it clearer in any reform proposal.
Thank you, Toby. One final question, I think is probably all we have time for. And if I could probably ask Brooks to provide his views on this initially, and then for the other panelists to react. There are parallels between the appellate mechanism that is being considered at UNCITRAL Working Group 3 and the WTO appellate body. But the WTO appellate body is pretty much dysfunctional now. It needs a minimum of 3 members. It has 1. No new appointments are being made. How would we avoid the process of an appellate mechanism, or for that matter, the multilateral investment court, becoming a hostage to changing ideology of individual states, which have the power within the system to influence the composition of a court or an appellate body?
Well, we'll have to learn the lesson of the WTO and design the new mechanism in a different way. And it's the simple answer is that we take away the individual government's abilities to block a constitution of any instance, first or second instance, and that's the easy answer. The design.
Any further comments on any of the?
Yeah, no, I think Brooks is right, and it's really about how one designs it, and it also harks back to what Mr. Justice Chandrachud was saying earlier about learning the lessons of the past. And on that front, even though there is at the moment a dearth of arbitration practitioners, we've got quite a few experts that have, for example, been involved in the creation of ITLAWs, etc., etc. So there is a wealth of expertise, as you would expect, at the UN. And it's really going to turn, I think, as I was putting it earlier, the good faith of those that are going to be working on the detail of that court. Are the politics going to re-emerge during the negotiation of that convention? Or is there actually a willingness to create something which truly works and is truly neutral? And I'm hopeful, because when you look at the motivations, for example, of the 27 EU states, it's because of the backlash. And so for them to now come and create something that would be open to criticism on that front would be, I think, quite difficult. And that's an anchor group of states that is there. And so we will see. It's going to be politics and realpolitik, but at the moment, there's no feeling that it would come in the way of trying to find a system that works.
Thank you. I think that's all time for in terms of these discussion. I'll hand over to George for his final concluding comments.
Thank you. It was a very interesting discussion. We've crossed the time limit we initially set, but the discussion could have gone on and on. We've tried to put it into a capsule what UNCITRAL working group has been deciding or debating on for over close to half a decade. If you look at initially, this discussion started in 2015 in UNCITRAL to bring the topic. So we've tried to have everything in less than 2.5 hours, but a discussion which can go on and on. A very good, interesting discussion. We had a very interesting panel. We hope to have a part 2 of this sometime, might be at a later day when we can deliberate on this further. But on behalf of UNCCI, may I take this opportunity to first thank NLS and Professor Sudhir Krishnaswamy for hosting this. I also take this opportunity to thank this wonderful panel, Dr. Justice Chandrachud, Salim, Toby, Brooks, for taking the time out from their busy schedule and coming here today on a Saturday evening to speak at this event. Perhaps one of the advantages of something positive during this time of pandemic is to get along such a panel from different parts of the world, from diverse parts of the world, to come together and speak at such events. I also take this opportunity to thank Mr. Gourab Banerji, the Vice Chairman of UNCCI, and my co-moderator and the one who put this whole thing together, Pramod Nair. Last but not the least, I take this opportunity to thank all the co-hosts, NLS, ICA, PCA, and our media partners, LiveLaw. Thank you, stay safe, and hope to see you all at better times.
Thank you, everyone.
Thank you.
Thank you very much.
Thank you.
Thank you very much. Bye.
Bye.